In United States Supreme Court news, the United States Supreme Court has decided a case today without oral argument, which sometimes happens. So they wrote an opinion based simply on the papers without oral argument, which they can do, obviously. So they deny a lot of cases, of course. Sometimes they reverse and remand in light of other cases. And every once in a while, they'll actually come forward with an opinion in a case based on just the papers. And they just did that just now. So here is a case that was decided in the case of Calcutt versus FDIC. So we will read this case and see what it has to say. Let's get started with this. The FDIC brought an enforcement action against the petitioner, who was a former CEO of a bank, for mismanagement of loan relationships in the wake of what was called the Great Recession. So this guy runs a bank, but he's not running it in exactly the way that he's supposed to. He's doing things not quite the right way. And the FDIC, which is an insurer of the accounts, takes notice of this and is like, hey, we can't help noticing that you're creating these loans in an improper way. And therefore, this poses a potential risk to the bank. And because we back the insurance deposits of the people who give money, that's a real concern for us because you're increasing our risk profile. So they brought this action against this guy. After proceedings concluded, the FDIC ordered that the guy be removed from his office, prohibited from banking, and assessed $125,000 in civil penalties. So apparently this guy screwed it up pretty hard. He was doing some loans in an improper way, apparently a very improper way. And the FDIC said, okay, you don't get to be a bank CEO anymore or do any kind of banking of any kind. And you also owe us $125,000 in money. So that is the end for you, sir. But he, of course, is sad about that. So he petitioned for review of all that in the Court of Appeals. The Court of Appeals determined the FDIC had made two legal errors in adjudicating, but instead of remanding back, the sixth agency conducted its own review of the record and concluded that substantial evidence supported the agency decision. So they said, hey, okay, FDIC, you screwed this up, but we think that it's not that big a deal and your decision stands. So we don't have to send this back to you. We think that, these are errors that don't matter, which is often what courts of appeal do. You have to find errors that matter. And the Sixth Circuit said, this is an error that doesn't matter, so you still lose. The Supreme Court writing saying that conclusion from the Sixth Circuit was an error. It is a simple but fundamental rule of administrative law that reviewing courts must judge the propriety of the action solely by grounds invoked by the agency. So when it comes to admin law, the courts of appeal can't fix this by substituting different legal rationale, which they could do in the case of review from a lower court. So you'll sometimes see that. You'll see a case at a district level or even the Court of Appeals, and the Court of Appeals or the Supreme Court, as the case will be, will say, okay, your legal rationale was wrong, but we have a legal rationale that would work because these are all questions of law, right? So we will substitute our legal rationale for your legal rationale. And now this is the legal rationale, right? You came to the right decision, but for the wrong legal reasons, and we can fix that. Well, that being the case for courts, that is not the case for administrative procedures because administrative is different than courts. It is executive versus judicial. And so we do things differently. So the only way a court can uphold an administrative decision is based on the administrative decisions. They cannot change the rationale. An agency's discretionary order may be upheld only on the same base articulated by the agency itself. So you can't do that substitution, which you could do if it were a lower court. By affirming the sanctions based on a rationale different from the one adopted by FDIC, the Sixth Circuit violated this rule. We accordingly grant the petition for certiorari limited to the first question presented, the judgment of the Sixth Circuit, and order the court to remand this matter to the FDIC so it may reconsider the case anew in a manner consistent with the opinion. So, yeah, no, you can't just substitute one for the other. You have to send them back to the administrative agency to make the decision in the first instance. You can't just substitute your judgment for their judgment. Thus, that brings us to the end of this case, which was decided on the papers that were filed. Someone filed a petition for a writ of certiorari, and the Supreme Court decided, yes, we grant it, and yes, here's a decision. So they just issued the decision with the grant. Yes, request for review granted. Here's your decision. Because we don't need to have oral argument. Because this is clear on the law. So we're just doing this per curam, issued directly. You screwed it up, Sixth Circuit, fix it. So this will have to be reversed and remanded back to the FDIC after being reversed and remanded back to the Sixth Circuit. So it'll have to be reversed and remanded to the Sixth Circuit, then to FDIC with instructions. We'll then have to consider all this in the first instance to fix all this because, you didn't follow the proper process. And we believe in due process, including things like, proximate cause. So, fix your mistake, try harder. And that brings us to the end of discussion of this case.